Strata reform will simplify the dispute resolution process. Currently, if you have a strata dispute, the dispute could be heard in one of 4 different forums, namely 3 courts or 1 tribunal. Research has shown that the State Administrative Tribunal, or SAT, is very effective in resolving strata disputes. The strata reforms will make SAT the one-stop shop for strata disputes. Channeling strata disputes into a single specialist forum will provide all strata stakeholders with access to a cost-effective strata dispute resolution forum. SAT's powers will be increased to enable SAT to effectively resolve strata disputes. The reforms will improve SAT's ability to streamline procedure and deliver justice more efficiently. SAT's powers will be expanded. Currently, the maximum amount SAT can order a person to pay in a strata dispute is $1,000. Reforms will remove the monetary limit on orders made by SAT in a strata dispute. SAT will also be given broad powers to amend and repeal all types of bylaws and resolutions. SAT will have the power to enforce statutory duties imposed on the developer or strata manager. Members of a strata council will have a statutory duty imposed on them to act honestly and in good faith. SAT will be given the power to remove a council member if they breach their statutory duty. Currently, SAT can only make an order imposing a penalty for breach of a bylaw if that bylaw specifically states that a penalty is to be paid. Most bylaws do not specify that a penalty is to be paid when the bylaw is breached, which means most bylaws cannot be properly enforced. Reforms will give SAT the power to make an order imposing a penalty for the breach of any bylaw. All that will need to be proved is that the strata company served notice and the breach has continued. Currently, disputes between a strata manager and a strata company cannot be heard by SAT. Reforms will give SAT the power to resolve disputes between the strata manager and the strata company. SAT will be given the power to terminate a strata manager contract, to order a strata manager to pay damages to the strata company, and to order the strata manager or strata company to do or not do a specified act. SAT can order the strata company pay damages if the contract is terminated, where SAT finds that it should not have been terminated, and the strata manager has suffered a loss as a result of the termination. SAT can also order the strata manager pay damages if there has been a breach of the statutory duties or the contract by the strata manager, and the breach has caused the strata company to suffer a loss. The strata manager will have a duty to disclose any commission they receive to the strata company. SAT can order the strata manager pay the commission they receive to the strata company if the strata manager breaches this duty by failing to disclose the commission. The reforms will streamline procedures so that SAT can deliver justice more efficiently. SAT will be given the power to make summary decisions where the facts are clear-cut. SAT will have the power to award costs in strata disputes, and people will be able to apply straight to SAT to resolve a strata dispute without having to go through other dispute resolution processes. SAT will be empowered to resolve disputes between buyers and sellers of strata arising from the seller's statutory duty to disclose information. SAT will also resolve disputes arising from community title schemes, leasehold strata schemes, and staged strata developments. More information on the strata reforms can be found on Landgate's website.